All right, breaking news on your screen right now as we're just getting updates where the Supreme Court has scrapped some provisions in the cyber laws. What we're seeing, strikes down section 66A of the IT Act is what we're tracking right now. That's a big development that's been, that we're just registering right now from the Supreme Court, section 66A on punishment for offensive internet postings. Remember, there's a huge confusion as far as how these developments were playing out. The language of it did have a little bit of a grey area there, and they've scrapped some cyber law provisions. That's a big headline that's just coming out of the Supreme Court right now, Sunanda.
Absolutely. So do remember that, of course, the Supreme Court had reserved its verdict on a batch of petitions which had come in really challenging some of the provisions under that. But let's try and understand that in greater detail, how that's going to pan out, what it's going to mean. Prashant Mali, lawyer as well as cyber law expert, joining us now. Prashant, appreciate you joining us. Let's start by asking you, so certain provisions have been scrapped, essentially the punishment for posting of offensive or allegedly offensive material, that has been scrapped. How are you reading this? Is this going to be a big move in terms of, you know, bringing out a level playing field as far as the IT Act goes?
Yeah, now what has happened is 66A had this very vague word called grossly offensive or having menacing character.
Yeah.
Now, and it was left for interpretation to a local police officer in a police station who may not understand exactly what does a grossly offensive or having menacing character means, and he can interpret it widely to his to his convenience, or for his political whatever will he has. So this needed to get altered. So exactly what Honorable Supreme Court has done right now is trying to remove this very vague words called grossly offensive or having menacing character, and that suits well. It could be later amended, and some certain words which are important and which could be understood very easily by our police machinery could later be added to this.
So Prashant, how would you see this move? Would you hail this as a landmark announcement here coming in, a judgment coming here from the Supreme Court?
Yeah, this is a very important, very landmark judgment which Supreme Court has delivered, because 66A was definitely been used by political class to settle their differences and to settle those people who are trying to voice against this people or to voice against government. So it was bringing in something which is called as chilling effects in the system. When you are oppressing somebody who is speaking out and there is an action against you, then obviously there are other people who really want to vent your voice. They are not able to do it, and that brings in chilling effects in the system. So now with removing this this particular grossly offensive word and this part of 66A, this will bring in more freedom of speech in the minds of people, but which should be used by due care.
Prashant, what about the government's contention that it was not trying to curtail freedom of expression, but that it said there has to be some method of filter, some kind of regulation really of the vast cyberspace, of the vast internet space? What do you have to say on that?
I am really supporting of this, because if you see when it comes to the ladies, then there are a lot of things which has been told about these girls or ladies, and dirty words have been used against when they are describing even a normal communications. Now this has to be somewhere defined in the softwares of these giants, who earn huge amount of revenue out of our country, and they don't support our cultural values. So Google, Facebook, and all others should actually implement some kind of filters based on discussions with government, where some pre-filtering can be done. It is not absolutely impossible. It is possible. The possibility is to be there. At least they should make some efforts towards it, so that we at Indian users feel relieved about that they are doing something for India from where they are using huge revenues.
Prashant, but it has taken some time for the Supreme Court to really come out with this judgment. On the 26th of February, they had reserved their judgment, saying that quashing this was not the solution because of the possibility of abuse. So it hasn't really been an easy case for the Supreme Court to also decide on, has it been?
I feel that the recent whatever has happened in political space, and specifically in UP, Uttar Pradesh, with Azam Khan's matter and other things which were happening around the country, made possibly Honorable Supreme Court think against it. But let me assure you, it has not struck down the complete section. So it has struck down certain words which were really not defined properly in the Act. government could have defined this as sections before and this words before, and these words could have been remained.
All right. In fact, we're getting Gopal Jain, Supreme Court lawyer as well.
Prashant, thank you for your patience. I just want to come back to you and talk to you about in terms of those filters which are being possibly suggested as far as some of the other sections which have been upheld go. What are your own comments on what possibly those filters that need to be put in place should look like?
Now there are 66A was in 3 parts. It was part A. Part A was grossly offensive and menacing character. But part B and part C, which were actually for sending mails which are annoying, or the other part which is an anti-spam section, even though this word anti-spam was not used, has to be there in Indian jurisprudence, Indian law. The reason is, then we can actually, the government can emphasis on filters which this social media sites can actually implement, and there could be various illustrations which government or any committee can come up and give to this social media organization, and based on these suggestions and illustrations they can implement certain filters which can be applied to any social media site or email provider sites or blogging sites, where they can filter out certain content. And secondly, very important is sometimes a person does these things in a moment of tiff. Then this section should, instead of directly punishing that person for doing this, it should have something for him to come back and say sorry or remove this defamatory matter. So something should be built into the law itself, so that once things are removed or they settle outside the court or settle outside the police station, things should not be brought to criminality.
Manali Singhal, I want to come back to you.
In fact, Prashant, just a comment here. If one actually has to look at the way this actually really played out from the start to now, how would you encapsulate as to how the events have played out, and now with this judgment coming in, what does it finally signify?
See, when the whole judgment was going across Supreme Court, Honorable Supreme Court had gone through various emotions, where it had looked into various things. If 66A is struck down, then what? Which section prevails? Which section prevails for online defamation? For when somebody defames somebody on Facebook or Twitter or blog sites, then what? So the decision for prolonging this kind of landmark decision was because of this. Because then, if not 66A, then what? And it has gone through lot of thought process. When you hear honorable justices various comments on various hearings, then you would come to know that they had gone through various phases. But the recent events which happened in our political landscape or on the online landscape, whether it is the documentary which was aired on the YouTube, or whether the matter which happened in UP, all this may have pressurized, may have brought to some conclusion that 66A, rather than helping the society, is denting what is called as freedom of speech, and it's violation of Article 19(2) of Constitution. So because of this, Honorable Court must have come to this conclusion of striking it down.
Okay, Prashant as well as Manali, if I can request for both of you to stay on with us. We're being joined as well by Hitesh Jain.
So clearly we're all waiting for more details and more clarity in that sense. But Prashant, just a closing comment from you here as well, as far as how you read into this. And Hitesh is raising probably a fair point as far as the implications going forward. Just your comment on both those factors.
Yeah, if you ask me personally, then instead of completely striking it down, there could have been some rules and regulations made for implementing 66A. That could have been fair, because there is no other section right now available equivalent of 66A in even IPC or even in the IT Act. So if rules could have made, or a time frame could have been framed to frame another section under IT Act for managing such kind of online defamation, that could have been a better, more people supportive, online netizen supportive kind of view. But right now, if it's completely struck down, we have what is called as vacuum when it comes to online defamation. it is only standing with a civil section and a criminal section which is not implemented that seriously when it comes to IPC.
Okay, gentlemen, very fair points being raised by both of you, but Prashant, specifically on the point that Hitesh has raised as far as now there being more confusion rather than reduced confusion because of this, the provisions being struck down, would you agree that's a fair point? And also as far as the prosecution under the IPC, would you agree that all of that is fair? Do you see that now it's going to be transparent going forward, or do you expect there will be more confusion?
There will be definitely confusion which section to be applied, because when it comes to online, certain words like email, transmission of data is not used in sections in IPC, because those sections were defined and added in IPC much later when even internet was not there. So now interpreting them in context with online will become more difficult for police. So we have to come with some kind of section which is replacing 66A with more clear words. IT Act needs to be amended, and certain sections which actually looks after online defamation needs to be added prompto.
All right, fair enough. We'll leave it there. Thank you so much, Prashant. Thank you so much, Hitesh, as well, for your thoughts as far as all these developments are concerned and how you are reading it into going forward. Let's also get another view in. Rajiv Chandrasekhar, MP for Rajya Sabha, is joining in right now. So thank you so much for taking the time out. I've been reading some of your